moved to Texas like a lot of landmen did in the mid 2000s. And the next thing you know, we're drilling horizontals and we're drilling big gas wells, and everything was 640 plus or minus 10. Then we flash forward, technology advancing, just seeing this evolution of just general kind of practice for drilling long laterals and unitizing and making use of these existing units. And then today, like, everything's an allocation well, it feels like in Texas. And I just thought it'd be a cool conversation.
I know that the story of this multi-track development, it's really a story of industry and the legal side of the house trying to keep pace with each other. When I was in-house, you couldn't do it back then. And so if you look at the stuff we're doing now out in the Delaware, I mean, with 3 sections, 4 sections, it's just been cool to watch that progression.
Land insights, market trends, industry experts. Welcome to the Land Department Podcast, the state of land and energy as we see it.
Brent, like many topics we have on this show, I have no idea what we're talking about. So I'm excited to learn. I'm going to let you guide the conversation. Why don't you let us know how we got Ben on here today?
Yeah, well, also the greatest thing is that I can invite smarter people than me onto this, and then I can just kind of follow their lead. So
there you go.
It works out. No, yeah, we got Ben Holliday on the podcast today. You follow people over your career in land, and always seen Ben, met Ben a number of different times at all the industry things, but haven't got a chance to really sit down and visit with him. And he always puts out great content. He does a lot for, seminars and things like that. And I had this concept. I wanted to talk about pooling and evolution of unitization and all those things. And I reached out to Ben and he said yes. So now he's a podcaster, and he's here. Just tickled to have him on. So Ben, welcome to the podcast, man. Thank you for coming on.
Yeah, thanks for having me, guys. I think this is the first podcast I've ever done. So,
oh man,
it's fun.
Well, you got the mic set up. You're ready to go. You got your headphones look more professional than us. You're ready.
Yeah,
I do my best.
Yeah, no, you're gonna do great, man. And the good news is, like, they're just gonna get better from here. You're gonna have better hosts, better podcast opportunities.
Nah, I doubt it.
Well, yeah, no, man. You got a pretty interesting career. It's you see people who kind of followed your path. But I always think it's interesting to kind of hear how folks got from landman work to doing legal work and law school and having your own practice. Man, just tell us your background.
You bet. Yeah. So I went to A&M for undergrad, and I was in the business school, and I wasn't sure what I was going to do. I graduated in 2003. And I really thought I was looking more towards a career in like law enforcement on a federal level, or the intelligence community, or the military. And I said, I'm going to just try this law school thing, because some of the recruiters had said, hey, if you go to law school, you're only more attractive as a candidate for these roles. I was like, okay. So I never really had any real intention of practicing law. And I go through law school. I worked for the U.S. Attorney's Office. I worked for the Department of Justice. And among other things, I worked for the Army. And the constant feedback I was getting from my mentors was, this job is great until you hit 40. And then once you got kids in school and stuff like that, it's tough. And then all you got to do, either you got to keep it up here, or you're going to have to go do like criminal defense. And no, we don't want to do that, right?
Yeah.
And so I was like, man, I was really disillusioned my third year of law school, to the point where if someone had come to me and said, hey, we'll cancel your student debt, because I paid for it all on student debt. I said, cancel your student debt. I'll give my law degree back. We'll call it even, whatever. And in my last semester, I took oil and gas law. And man, it was just like a light went off. And I learned about, I'd never heard of a landman. It sounded like a fake job, right? Landman, like, what is that? Landman. And I said, man, this sounds awesome. Like, I really wanted to. I went and talked to my professors, and they were trying to talk me out of it. They said, you don't want to be a landman. I said, no.
They bill by the day. This is not what we're...
Exactly. Yeah, but I was like, I was 26 and knew everything there was to know, right? And so pretty soon after, I took a job with a guy here in the San Antonio area. And next thing I know, I'm down on the border leasing. I was living out of a hotel room in Corpus. I was straight up in the field, landman, all the stuff. And that lasted about a year. And I moved in-house with David Arrington out of Midland. Yeah. So if you don't know David, he is like He's the last of a dying breed. He's the last,
is, man.
one of the last of the wildcatters. I mean, he is.
He's a land hustler. He's got his hands. You talk to anybody who works for David, and you're like, well, what are you doing? He's like, well, I'm doing this land work on some real estate thing, and we're also going to drill a well under it. Like
Right.
He's an entrepreneurial guy. It's a pretty cool
I mean,
business.
One of the best ways to describe it, there was a billboard. I started out in the Barnett. I moved to Fort Worth to go in house. We're running 4 rigs at the time, and he had a billboard that said, "If you don't have a gas well, get one. Call David Arrington, 817." You know, and we all wanted to take some welding torches and cut that sign down because we got so many phone calls, about it. But I learned really early on. It was really cool to work for him and some of the other guys there. Keith Frank was the land manager. He was a big mentor of mine. And, you talk about the hustle. I just learned, like with David, he would say, don't pay more than $10,000 an acre. And we'd go out there and sit across the table and we'd get the lease for like 12,000 an acre. And I'd say, man, Dave said, don't go past 10. Nah, watch this. We'd go back and he'd chew on us for a while. And then he would say, "Oh, I can't believe you. I told you not to go past $10,000 an acre, man." And they'd start looking at the map and right without missing a beat. It's like, do they have anything else they want to lease? Right. So it was cool, man. But I got to go. So anyway, I got to see a bunch of stuff. We were still pooling back then. And we were really hampered. The example I give to a lot of people now when we talk about pooling is like when I was in house, one of the wells we drilled is called the Black Gnat in Johnson County, 70 acres. It was like a triangle. It had gotten left out of a trade in true Arrington fashion. He wanted to say, watch this, I'll drill it.
I'll get right in the middle of it.
It was like it was 90 degrees off orientation, perpendicular to how your wells are supposed to be stacked. 900 feet, and it was a BCF gas well. It was like one of the best wells we drilled in the basin. And the unit that we pooled was 69 acres, right? And so if you look at the stuff we're doing now out in the Delaware, I mean, it was 4 sections of land all in one wellbore, and you couldn't do it back then. And I know that the story of this multi-track development, it's really a story of industry and the legal side of the house trying to keep pace with each other. Yeah. And what you can do, we'll talk about that when we get to allocation wells, but like with EOG, it was really one of the EOG and Devon were the 2 leaders of the allocation well movement. It's because they had the technology that could go out so much further than what their lease allowed them or what conventional wisdom said allowed it. And they said, you know what, we're not going to strand resources. We're going to go get it. And it's just been cool to watch that progression. And then I'll probably get into a little bit too, you look around, we do a lot of stuff in New Mexico, and I personally do a lot of the compulsory pooling stuff. And you have whereas in Texas, you had this organic industry came up with allocation wells and the way to do it. And there's no law, there's no court case, there's nothing. Yeah. In New Mexico, you got the exact opposite. Yeah, legislature.
Very structured. Here's the rules.
Super structured.
Yeah.
Yep. There's a repeatable process and by the book. And both of them work really, really well. So it's been cool. It's been cool. I guess it makes me old to say I've been doing it long enough to watch it change,
Yeah. Well, that was kind of what was made this an interesting topic for me is similarly, started doing a little work in South Louisiana. We're doing conventional wells, moved to Texas like a lot of landmen did in the mid 2000s. And, next thing you know, we're drilling horizontals and we're drilling big gas wells and, everything was 640 plus or minus 10 because we were working off a standard kind of producer's form. Then, and that's happening in East Texas. And then you go down to South Texas and, I don't have 50 leases in my unit. I've got 1. And oh, by the way, it's not a producer's 88. It's an operating agreement. And I've got retained acreage and I've got all these abilities to, the structure of my agreements dictated what I could do and how I could develop. Then, flash forward 2015, 16, the Permian happens. And you got 100 players, fighting over the same acreage and technology advancing. I think you said it's like the law is always trying to catch up with technology. And, and then you start seeing, okay, now we've got everything held by production, but now I got to go to a deeper depth or I want to drill, additional unit wells, but I want to be able to drill them 3 miles long. How do I handle that? And so just seeing this evolution of just general kind of practice, for drilling long laterals and unitizing and making use of these existing units. And then today, like everything's an allocation well, it feels like in Texas.
In Texas.
Yeah. So I just thought it would be a cool conversation to just kind of almost go back to the basics to talk about, just what are the different types of unitization and pooling, and then bring it up to today, right? What we're seeing in Texas and what we're seeing in New Mexico. And it's the same rock, drilling to the same depths, but different circumstances and different, ways of going about it. And I just thought it'd be a cool conversation. So maybe with that, let's just run us through the basics of, the types of unitization that you see. And we'll keep it within Texas and New Mexico.
Yeah. So, I mean, pooling in either Texas or New Mexico, what you're doing is you're saying I have multiple tracts of land, right, that I can drill on each of them, but I want to combine them into one block so that I can drill across it and I don't have to, I can just treat all the different tracts in the unit as one whole thing. And so what you're doing is when you pool acreage, you're combining it so that everyone that owns an interest in there participates in the revenue proportionally. So you're taking that external tract line, the outside of your unit, and you're just eradicating the internal property lines inside of it. So now you can just go develop your tract. And at least the way it developed in Texas, you had pretty standard lease language that would say, let's just call it 640 plus 10%, which is practically 704 acres. So you could hold that many acres in your unit, which worked for a long time. And then until all of a sudden I can drill a lateral longer than that, like you mentioned. So we've now gone beyond holding our acreage. We're now developing it. It's HBP. It's jigsaw puzzled into this mix mash of leases. And the lease won't allow me to drill across the line expressly, but there's nothing that really says I can't, because I have the right to drill on this side of the line. I have the right to drill on this side of the line. Why can't I drill across the line? That's essentially how we started moving past the pooling thing. So pooling, what it means is you're taking all the tracks within an outer perimeter and you're combining them together so that they participate proportionately.
Yeah, and portion of their acreage contribution to the unit as a whole, and that's how everybody's paid, right?
Right. And the reason why allocation wells took a long time to develop is there was a case, Montgomery versus Rita Barker, I think is the name of the case, and that case said you're not allowed to pool someone's interest unless you have permission, right? So if I want to combine your tract and Khalil's tract, you have to agree that I can do that.
Yeah.
If I'm going to treat them as one unit.
If you've got, okay. Like, are you talking about multiple units, or are you just talking about multiple tracts within a area pre-unitization?
Both. So, but it evolved as tracts together, right?
Okay.
So before I even pull my, unlike New Mexico, where you can go in and essentially force people to come into your unit, in Texas, it's a matter of contract. So someone has to give you permission to treat your tract within the unit as a proportionate share of the whole.
Yeah.
One of the ways that I first thought about this as a landman, I continue to think about it now, is what is pooling? It's anytime my interest is getting diluted. If my interest is getting diluted, then I have to give that authority to you to dilute it. And if I don't give it to you, you can't do it. And that really, for a long time that works. Then we start doing horizontal wells. And now we're starting to see, I would call it probably 2007, 8, and certainly by 2010. Now we're starting to put square pegs into round holes because we're trying to apply horizontal development to vertical leases, and it's not adding up. And then for a while, it worked. Okay, fine, 700 acres, we can stack our units. And then all of a sudden, it's like, well, I can drill 1,000, and that's where things get kind of dicey.
Yeah. So let's kind of walk through that. So, mid 2000s units and I'm just using a decade here, but 700 acres units or section, 640s start getting put together depending on what part of the country you are in Texas. And then so you got units next to each other, right? And they're formed, they're established, they're adjoining each other. technology advances, right? Now, to your point, it becomes more economic to really drive the economics of your production. Hey, I can drill 10,000 feet, just as easy as I used to be able to drill 5,000 feet. How do I do that? Like, how do I accommodate that? So that's the progression. So when we get to that point, all right, now I've got two existing units together, pre-existing units, but I want to drill through both of them. How did we handle it then? Like, what evolved then? Was that when kind of PSA, production share agreements, started to become kind of popular, or did we go just straight to allocation? What was that?
It's funny. We started with allocation, flirted with PSA, and then some people still do PSA wells, but then it went pretty much back to allocation. And the case that kicked us off, gosh, I think it was 2010, maybe earlier, I can't remember.
Yeah.
Devon. So the reason why you couldn't do that before is in Texas we have a thing called statewide Rule 37. That Rule 37 says I have to stay 330 feet away from your lease line. I cannot locate a producing portion of my well within 330 feet of your lease line.
Yeah, geared at protecting against drainage.
Right. So I'm not draining the neighbor. And Devon had 3 old units that were in the right orientation to drill a well all the way across them. And they looked at it and said, yeah, I'm not allowed to drain this tract, but I'd be draining myself. Right. And so statewide Rule 37 has a deal called you can apply for a waiver, which says, hey, we've gone to the commission, we've put everybody on notice. We want to drill closer than the 330 feet. If nobody protests, you can do it.
Yeah, that's the
Or
Rule
people say
37
that's okay.
exception that you hear.
Rule 37 exception,
Yeah.
right.
Yeah.
And so Devon looked at it and said, well, we're the operator of these wells. To the extent we needed an exception, we just give ourselves an exception. And they wrote, so they applied for this thing at the Railroad Commission. The Railroad Commission didn't know what the hell to do with it. Gets kicked around, hot potato, all inside. And then finally, the Railroad Commission says, essentially, look, we don't know what this is. We don't even know if it's legal, but there's no regulatory reason not to allow you to do it, right? So I'm saying I'm not absolving you, right?
But
I'm
not
saying I
you
won't get you
can't.
in trouble, right? It's like when my kids come to me and I'm like, I'm fine with it.
What'd
but I
your
don't know
mom
what
say?
Your mom's going to say, right? So,
And if it comes
you're
down to it, I'm going with your mom.
exactly, 100%. We all survival instinct will kick in at that point.
That's right.
So the Railroad Commission issues this, what they call an allocation well permit. And they said, we don't really know what to do with it, but there's no regulatory
that.
reason to deny it. And so therefore, Devon goes and drills the well. And then we didn't have a case until 2012, the EOG Klotzman case. So EOG, same situation, 2 units, they offset each other. They offset their own unit. They say, I can administratively waive this Rule 37 exception. And one of the leases in there had language that said, you can't pull my tract under any circumstances.
Yeah.
And so then the fight becomes, is that allocation well pooling or not? And the first thing, the way these always get attacked is they don't start with a district court case. They'll start with trying to have the permit revoked. Because if I can revoke your permit, it's dead in the water.
Yeah.
The well's dead. So this fight always starts at the commission. And the commission, at the Railroad Commission, they had a trial, and as to whether they could pool or not, the hearing examiner that heard it, the way these decisions get made, it goes before it's almost like a court, and there's a judge. And then the judge will hear all the evidence, and he'll issue what's called a proposal for decision to the actual railroad, the elected railroad commissioners. And they, 99 times out of 100, they go with that proposal. So this time, have our little trial. The hearing examiner writes this extremely detailed proposal, like we should deny this. This is pooling. This is wrong. It shouldn't. We can't allow operators to do this. All sorts of stuff. It goes up to the commission, and the commission hands back their decision. It says no, and their decision is like 1 paragraph. No, we
Go
can do
for
it. They're yeah, exactly. Go for it, basically. And so, so then this case gets Go ahead.
Yeah. So do you think so that's just an interesting thing because it was always, I remember when all this happened, like, oh, wow, what's this thing? Like, oh, you can do this now? Like, we're not going to get in trouble. And
Right.
it was just like the possibilities are endless at that point. But nobody, I remember it was this thing like, is this going to bite us? And then before you knew it, the industry's like, well, if we all go, it's a herd mentality. They can't sue us
Right.
all. You know,
Exactly.
they're not going to
That's where
stop
we're
us
at now.
all. Yeah.
People have tried, man. Every other session, somebody tries to file some legislation to define an allocation well or rein them in or do something, and it dies because
Yeah.
no one wants to be. And the same reason there hasn't been a court case, I believe they've settled everything because nobody wants to be the one that gets their name put on the anti-allocation well rule. And then at some point you have a critical mass like we do now where, okay, what are you going to do? We have 20,000 allocation wells.
Stop the whole industry. Yeah. And I wonder if there had to have been at that time, and it's probably why the commission ruled that way, is there had to be a lot of industry push for like, look, we got a problem, Bruno, we got to solve it. You know, the whole thing about, technology advancing, regulatory mentality or legal framework, that had to be that tipping point where they're like, look, leaning on some of these railroad commissioners, that kind of stuff.
Right.
Let's go.
Well, they're certainly responsive because they're politicians, right? I mean, and through AAPL, the Houston chapter, HAPL has a lobbyist, and we go participate like once a quarter in their sessions. And the lobbyist is great. And
he's been on the podcast, actually.
Has he? Oh, yeah. Okay. Todd says all the time, he's beating in my brain, the number one job of a politician is to come back next time and get reelected, right?
Yeah.
So
that's exactly what he told us.
That's what they start thinking about. And I think they looked at this and said, you're right, we have a problem. We got to get out ahead of it. And the general stance of Texas is to encourage development. Like we don't want to be restraining development. We want resources to get developed because just even at the state level, that's more severance tax, right?
It's at the crux of what, is appealing about Texas. It's a business friendly environment. We don't advance by regulation. We advance by, innovation, company, entrepreneurial spirit. It's pro-business play. So not surprising that we went about it that way. But just kind of interesting to see how all that evolved. So, yeah. So, okay. So back to it. We, the gates were opened. The commissioner said, look, hey, this is good. EOG, drill your well. Like, how did we progress from there? You said we we went allocation and then we kind of went PSA and then now we're back.
So that case actually got appealed because if you lose the commission, you could go to the trial court in Austin. And that's everybody's nightmare because Austin, as you know, is a politically different environment than let's say, Midland. And the case settled. We never get there's no other legislation. There's no case law. As you mentioned, some people are willing to go cowboy and just drill allocation wells. Some people, companies are a lot more hesitant and want to find out. So the next evolution was this thing called the PSA well, Production Sharing Agreement well, which is really the right way to think about that is super pooling. It's like I have two pooled units and I'm going to combine those together by agreement. And I'm going to allocate production. So you're basically pulling pooled units together.
Yeah. And by agreement, that's an understatement, by agreement, because there's a ton of work involved there. It's not like, this is our agreement, everybody's enjoined. No, it's like you're going owner by owner, party by party, saying, hey, this is what we're going to do, sign off on it. And you know how that goes.
Kind of like a merger at this point? Like
you are essentially merging these two, because once a unit's formed, as I mentioned, as long as that unit is held by production, you've eradicated all the property lines. So you think of it as like one tract. Mm-hmm. And so you have two units offsetting each other and you want to put them together with a PSA. Now all of a sudden you're pooling those two tracts together. And so you have to remember in Texas, we can't dilute without consent. And so you had to get the consent of everyone, and people started saying, well, we feel like this is a more defensible position. It's more work, but it's a more defensible position. Yeah. And you mentioned it is a lot of work. And so the commission actually developed a extraordinarily informal rule of if you have more than 65% of the people sign off, then we'll grant your permit you go for it. And then if you get sued, that's your problem. But there's no regulatory reason to prevent you from doing it. And so, so people started doing that. But to your point, I think they just looked at the land cost involved,
Yeah.
and it's just astronomical. It's like, why would I expend all these resources and effort when I can just drill an allocation well?
Yeah. Yeah. And so we saw that as a service provider. There was a period of time where it's like, okay, well, out of abundance of caution, the Railroad Commission has given us this framework that at least they won't revoke our permit. We get 65%. So you had companies that were like super conservative. All right, we're doing this. And so there was a period of time where brokerage firms were doing a lot of that kind of work, just PSA work, helping companies consolidate these 2 units to be able to do it. But, you look at a place like East Texas, to your point, it's just not cost prohibitive because you may have to get 150 agreements secured to get to 65%.
On a good day.
On a good day, yeah. And then not to mention you're dealing with other operators, your neighbors, other working interest parties, and then that brings them to the table to say, well, remember that time, Ed? And then
100%.
Everything's you're breaking out the wallet every time you turn around.
Yep.
Everything's in negotiation. Everybody's the most important thing, and everybody's that's their opportunity for the gotcha. And it lasted about a year and a half.
Yep.
So that's kind of what led us back to the allocation. They were like, well, if it's all the same, let's go this route. So dive into that. Like, so the fundamental differences between, you've done a great job of just boiling it down to the basics of what a production sharing agreement unit was or well was. How is an allocation well different from that consent standpoint?
Right. So if we go back to like our pooled unit, right, we have 100% consent within that unit. Everyone's agreed. This is how we're going to do things. PSA, we have 65% of the people agreeing this is how we're going to split things up. With an allocation well, if you have the right to drill on each tract, it's up to the operator to allocate production from that well on a reasonable basis. So as long as they're not combining it and treating it as a pooled unit such that everyone participates proportionately, as long as they're allocating the production in that well to each tract on a reasonable basis, right? And so that sounds very loose, and it is. Then the Railroad Commission said you're allowed to do it. So how practically does that work? We really only see 2 ways. I drill across 2 tracts of land, and the most reasonable way people, and this is, we have thousands of these, and it's never been successfully contested, or at least not yet. You take the proportion of that lateral that's producing, right? So you start with the first perf and you end with the last perforation or take point.
Mm-hmm.
And my percentage of the producing lateral that's on tract A, I take, let's say it's 40% on tract A, 60% on tract B. I'm taking 40 cents out of every dollar, and I'm distributing it to the guys in tract A. Mm-hmm. I'm taking 60 cents of the dollar, I'm distributing it in tract B. And I tell them, prove that this isn't reasonable.
Yeah.
And so when you're crossing not 2 tracts, but in many cases, 10 tracts, so we'll get involved on the division order side where they'll provide, an operator will say, here's our well, here's the tracts it cross, here's the percentage of the lateral for each tract. Tell me who to pay. And then so we'll go down and break that out. And the theory is, I'm not pooling you because I gave you 100% of the revenue from your tract. Your tract is 10% of the well. I gave you 10% of the production. That's not pooling. I'm allocating all it to your tract. And so generally speaking, that is the formula that prevails. We call it the productive lateral formula.
Mm-hmm.
The only other variation we see, and this is typically when you're dealing with someone like some of these big ranches you mentioned down south, right? Like they have these like literally 50 to 75 to 100 page lease forms. I mean, it's
an operating
got everything.
agreement. Yeah.
It is. Well, it's a gotcha because you can't comply with all of it.
Yeah. It's an operating agreement that's meant to not be successfully operated.
Yeah. You're always
There's
in
a gotcha at every turn.
You're always in breach. But these guys, not only do they have sophisticated counsel, but they have, I'm thinking of the Faskins, I'm thinking of the Petties here in San Antonio. They have geologists and subsurface scientists on staff. And so they will look at it and say, this productive lateral deal, that doesn't work because the geology, the way it works in South Texas, there's karsting. So you might have 40% of the productive lateral on my tract, but you got 80% of the take
80%
points
of the-
because I know you had to plug back, you had to do all the stuff on track B, and so we've seen where they've forced that to be the allocation formula.
Yeah.
But
But
outside of
generally that has to be a contested thing where you're arguing your point and you got to come to an agreement between operator and a landowner or mineral owner.
right, and the operator really doesn't care how that allocation.
We're just mitigating risk. It's like
they just don't want to get sued, right?
Yeah.
Like I'm trying to drill my well and move on down the road, but those circumstances are pretty rare. Where you would have
I'm sure
someone
that's where that gray area is where you see litigation and see suits. If tract A has a more favorable royalty than tract B, like were they operating in good faith and doing those things.
That's a good point. That's a really good point. And actually, I've not. We don't handle once the well gets drilled.
Yeah,
we're usually my firm, like my guys. We're all out of the picture. We're on the.
You don't get to see the mess.
No, we don't litigate much. We litigate some, but not much. And so we don't actually get to see that very, very often. But to your point earlier, I really, I very much, because I'll give this talk all across the United States. I'll go talk to the North Dakota chapter, the APL, and all that sort of stuff. And one of the things I always brag on Texas is that we not only do we have an entrepreneurial state where we're coming up with ideas, but they're good ideas, right?
Yeah.
I mean, this allocation
things
principle,
that work.
It works for everybody. You're not,
Yeah.
We can, when we get into New Mexico, we can talk about how there's games you can play where the operator can wind up ahead,
Yeah.
But in allocation wells, there's really not that mechanism. And you have thousands of independent actors in Texas organically coming up with a business practice that works for everybody. And I think that's just really cool. It could have gone, there's a lot of opportunities for that to go a different direction. And I feel like industry was really responsible in helping bring this current state to place. So now allocation wells, we started with pooling. We expanded beyond, from a technical standpoint, what we could do within the confines of our lease terms. We tried PSA wells, too much work, too expensive. And then we moved on to allocation wells. And now, like you said earlier, there's so many of them.
Kind of becoming the state.
There's no looking back.
Yeah, all the cows are out.
That's right.
So let's just have one kind of little clarifying point. So you've got 2 units, right? And those units are made up of individual tracts of varying proportionate size to the unit. So as a mineral owner or royalty owners are getting paid in that traditional unit based on their contribution to the unit as a whole, right? They own 40% of the unit area, so they're going to receive 40% of the production of the wells, the initial wells drilled within the confines of that unit, right?
Right.
That's their pay structure. When you have an allocation well that would come in and drill, through 2 or 3 units, their production comes from their contribution of the lateral take point. So they may have been getting 40% of the unit production on those initial unit wells, but when it comes down to the actual allocation well, they may only be getting 10% of that well because it's really a formula of how much lateral goes through the particular portion of the tract that it was drilled through. Correct?
Right.
That's how it works.
It can get even more gnarly than that, because let's say you drill across 3 different pooled units now, and each has a 33% of the well, right? I take 33% and I split it amongst pooled unit 1. So that goes poof and disperses. I take 33% and I give it to unit 2 and poof, that disperses. And so it just keeps getting diluted down, because now when the unit's pooled, remember, it's one tract. So in drilling across it, if I have 10 feet in it, 100 feet in it, I'll allocate that number to it, but it's all getting divvied up proportionally.
Mm-hmm.
And so, our title opinion practice, we love it. When you give us like a division or title opinion with 3 or 4 units in it, and we have to do all the math, because it can get pretty crazy. It's when you start seeing people with interests down to the 7th decimal place, and
seven zeros and a dot.
Yeah.
Yeah. Well, I mean, that's just, people say that landmen and attorneys aren't going to be needed anymore in this AI age. That's
luck.
not. Yeah, good luck. You know, it's all the nuance.
Well, you know, I think it's funny you mentioned that because years ago, we used to get so the title opinion side. Dudley would do a run sheet and you'd send it to us, and you would have all the instruments printed out, and it'd be in a binder. It was really nice. And so we would take that and we would review it all by hand, and we would flow out the title on a big piece of butcher paper. Literally, we'd go get printer rolls of paper and we'd have them. And so I had this big drafting desk. I was like, I saw an architect one time. I was like, oh, man, it's also exactly what I need. Yeah, it's a tilted desk. It's, huge. So I get one. Actually, no, my dad and I made one.
Even better.
So we make one, and then within months, no more paper.
Excel.
No more paper. Right. And so it evolved, right? And so we became more efficient. And I think with AI, my take on AI is that it will eliminate some of the lower level tasks, but I think it's just going to make people more efficient. We certainly look at that as an opportunity and not a threat.
Yeah, that's the way you have to look at it.
I mean, if you think it like the oil companies, the mapping, right? The GIS, you used to have armies of people doing that job.
Yeah. It used to be me with a colored pencil. It's like.
Right, exactly. Oh, I've done it. And you put a piece of paper on top of it and you wipe it. Yeah, I've done that.
That's right. Dark on the outsides, light on the insides,
That's right. That's right.
But we could go down a wormhole on that. But for the sake of not squirreling off and my ADD kicking in, let's get back on the unit stuff. It's thrilling. So, okay, that just good distinction there. Wanted to kind of paint that, lay that groundwork. So, we've moved on to today. It's a pretty well-established practice. Drill your lateral, allocate production accordingly. There's nuance for take points. How much factors, you mentioned we touched a little bit on the lease, right? Especially South Texas, what they allow you to do and what it won't allow you to do. If you're going to drill an allocation well across a couple of units, is there a lease analysis component to that to say, what am I allowed to do from an allocation well standpoint? Like, what's that kind of well clearance process look like for attorneys and landmen?
For sure. Yeah, your number one job is always read your lease, right? Like when we talk about some of the CLEs I'll give about retained acreage clauses, and I always lead with, hey, we're going to talk about this stuff, but your lease might say something else. And what your lease says, because Texas courts will say they're incredibly consistent for the past 100 years. We're going to look at the language that these parties used in this lease, right? We're not going to, they're very hesitant to give these bright line general rules that always apply. So what the lease says will govern, even over general rules. And it's not that common that we'll see it, but there are, especially from that 2012 beginning of allocation well vintage, you'll see leases that say no allocation wells. That is a problem, right? That's when it goes back to Dudley and you guys got to get some curative and right. That's when you get the checkbook out.
That's right. That's right. So why would so let's talk about that. Why would a mineral owner say no allocation wells?
Man,
is there like a thing, or just maybe it was fear?
I think fear.
Ignorance?
I mean, if I look at it from my perspective, I get to work with land departments, and I was in the land department, and we are trying to maximize our production. We're trying to get as much oil and gas out of the ground as I possibly can. And if I drill longer laterals, that's more oil and gas I can suck out of the ground. And it's better for the mineral owner because they're getting a cost-free percentage of that. However, there have been some bad faith operators that have gone out and done some things they shouldn't. Maybe I drilled, 10 feet into your tract and I held it, HPP'd it, and then you have 700 of the acres not getting touched, right?
Yeah.
So there was a natural distrust on the mineral owner side of things. And so you have this new evolution. People don't understand it. And I think we're going out of human nature. If I don't understand it, I'm afraid of it. That's kind of many people's default setting. And, a good example, gosh, there was I won't say his name, but there was a landowner. When we moved to San Antonio, I spent a year kind of bridging while we were setting up the law firm, and I was running a Eagle Ford project for plains exploration. And we had a mineral owner, and man, he was ornery. And we got a title opinion back that said that he didn't own the mineral, or he owned the minerals on the road and he hadn't leased it. And so now we came to him and said, okay, sir, we'd like to drill across the road. We need to amend the lease. We're going to pay you. He's like, no, I don't know how you're doing it, but you're screwing me. And no, I'm not doing it. And so we, even in this months of meetings transpired where we broke it down on a per lateral foot basis. The longer I extend my well, this is how many more dollars you're going to get. And it was millions.
Yeah.
And he still said no. And they pulled the wells back, and they drilled the wells, stopped them 100 feet from the road. Crazy, right? It's not rational. And that's an extreme example, but I think that's informative of how some mineral owners are, is that, they didn't understand it until I understand it. I'm afraid of it. I don't like it. And
people fear what they don't understand. Right.
Right.
And that's kind of thing.
And you could talk to, like, for instance, San Antonio's got less and less oil and gas activity from an operator standpoint, but there's a huge oil and gas legal bar, and there's two sides. There's
all that
operator,
litigation, baby.
Right. There's the operator side and there's the mineral side. And I have a bunch of really good friends over at several firms, and we always butt heads about it. They call themselves the side of the righteous, and so it just depends on what frame you're looking at it. And but I learned from Mr. Arrington that when you're talking within the context of a lease negotiation, no means not right now, and you haven't paid me enough, right?
Yeah,
and so the allocation, right. So the allocation well prohibition is a way to for that mineral owner to get another bite at the apple. And I mean, that's legitimate. That's fair. I would do the same thing as a mineral owner, maybe. And so
it's all
I think
circumstantial, right? I mean, it is, that's kind of one of those things. One thing that kind of you touched on it, and I think it'd be just good to kind of unpack what you're seeing. So you talk about retained acreage and holding a lease, right? I drill this allocation well, I'm going to extend it 100 feet into your track, and you're going to get production on that 100 feet. It's going to be minuscule compared to if I would have continued through, and I've got 700 acres, but I've got 100 feet of lateral HBPing my track. So it's like almost industry standard now when you're negotiating a lease, everybody wants a pew clause.
Right.
How have we seen have you seen the evolution of pew clauses to handle like allocation wells, right? In that context. So is there anything that you're seeing there that people are saying, no, you're not going to drill 100 foot into my track and then HBP the rest of my 700 acres? Like, have you started to see that kind of sophistication in your kind of boilerplate leases in the Permian and South Texas?
Yes and no. The no would be because we're dealing with these vintage leases from the 80s, right? And they've been HBP'd or
forever.
I mean, we did a title opinion over in New Mexico where I want to say the lease was from 19 or something. I mean, these are 100-year-old leases that are out there. So on those, no. And then you get in this whole separate. We could do a whole separate podcast about retained acreage clause and proration unit and what does that mean when they tie it to the size of the proration unit. But to the extent we see these new leases, so we get less at bats with the new lease, new language, because it has to be an unleased tract that's just been leased that's now getting developed. And so that it's just far more common that we'll see an older HBP lease. But when we do see it, you have, you mentioned a proration unit is this number of acres you have to dedicate to a well for regulatory purposes. And there's a limit on the number of acres based on whether it's oil or gas. But there's an exception called Rule 86 that says essentially your proration unit is determined by the length of your lateral. So if you're drilling a 1-section lateral, if you're drilling a 3-section lateral, we can exponentially keep more acreage around the well bore, but it's just going to be essentially the well
factor of your lateral length. Yeah.
But it's a factor of your lateral. So so what we've seen is people tying that retained acreage clause to, it's not directly, the mineral owner bar is going to pick me apart for this, but it's essentially you're tying it.
You don't have to incriminate yourself, man.
Right. You're tying it to the proration unit size based on that statewide Rule 86. So if you have allocated that to your well for regulatory purposes, you can keep it. And if you didn't, you don't. And so if I take 10 acres of your 600, then the 590 are going to get released out under that retained acreage clause.
Yeah. It's all the nuance, and you start to see. I mean, all these things will present themselves eventually. Like you're going to have there's always that one circumstance, right? But it's certainly, to your point, I think we've unpacked. You've done a great job of that. Really, just kind of talking about the evolution of it and how it works. I think they're here to stay in Texas. I think there's too much water under the bridge at this point. I think it's a prudent way to operate. I think it's especially with consolidation, commodity prices doing what they do. You have to be productive at lower price environment. I think that's where we're probably going to be for the foreseeable future. So they're here, and I think they make a ton of sense.
Well, and just one point real quick before you leave that, even for them, we've talked about how my opinion is it's a reasonable way to allocate production, and it's not harming the mineral owners, but it's helping the surface owners too, because now all of a sudden, if we go back to that Devon example, if I was going to drill across those 3 tracks and I had to stop and drill 3 laterals, that's 3 surface locations, that's 3 frac tanks, that's 3 gathering facilities. It's
Absolutely.
And so not only is it more efficient for the operator, it's a lot more efficient or economical,
less intrusive
surface footprint.
Yeah.
Right.
Yeah.
Yep.
No doubt. And I guess so. Just one other thing, and then I want to talk about New Mexico. These allocation wells. We talk about super pads, and you see 6 well pads and things now. Is it pretty standard for those to have those big 6 well pads, but you've got 6 allocation wells drilled?
Oh yeah. I think even 6 would be probably light. I mean, what we're seeing
nowadays,
6 to 18 off a pad, and they're just it's just less. You get to drill your units faster, you get in and out faster, you're disturbing the surface less. And as we move into the discussion in New Mexico, that's important because it's important in Texas, but in New Mexico, it's a lot more likely that you're operating on federal land or state land. And they really, if you think these mineral owners in South Texas are tough, you haven't met the federal government.
The BLM. Yeah.
The BLM. And
so let's talk about that. So, we got fundamental differences, right? And there's a lot of reasons why they're different, but probably largely because New Mexico is more based on the, Rockies, federal state lands model. We see the Rockies tends to operate the same way because it's so largely predominantly covered by BLM and state lands. So talk about the fundamental differences that kind of led to this varying methods of development that we see today.
Right. So that's the biggest single difference from which all the legal differences stem, right? In Texas, it is pretty rare that we'll see state lands implicated in a title opinion or something like that every once in a while. But in New Mexico, it's 9 times out of 10, you're dealing with state or federal lands. So when New Mexico became a state, the BLM, the federal government, kept huge swaths of the land as federal land, and those minerals underlying it. And then when the state got the rest under what they have, this thing called the Enabling Act, and as they patented out land, they kept the minerals. So you will get some tracts here and there where they did not patent the minerals out, or where they did convey away the minerals, but it's pretty rare, or it's more rare than Texas. So you have either, if the state got it, from the federal government didn't actually release it, chances are overwhelming that the state kept it. And it's done really well for New Mexico. That's how they fund their schools. It's the whole state. If you go to Namogo, which I highly recommend, it's the best. It's one of the best events of the year. It's in Santa Fe. It's in October.
Yeah, that's great.
The New Mexico Oil and Gas Association, they really beat the drum on this. It's true. They say, I want to say it's like 60, 70%, 60% maybe of the state, at least education budget, comes from oil and gas. $35,000 per teacher last year came from oil and gas. So tells you the scale of what they're doing over there. But because you're dealing with the government entity 9 times out of 10, you're dealing with the same lease form. So there's going to be very little variation in lease forms. It's going to be one of 3 state leases or the federal
3
lease.
vintage leases. The same goes for the federal stuff.
Right. And so they'll change over time a little bit. But because the state government and the federal government is so involved, whereas in Texas, you have private mineral owners, private operators developing an organic solution like allocation wells. Here you have the government saying what you can and can't do. And so they came up with this system of compulsory pooling, which is it can be when you're a landman or an attorney and you start working in New Mexico, it can seem like the craziest, most opaque system. There's the statutes, but there's very little published about it. I had to just read the statutes, break them down like I would have in law school, watch hearings for 6 months to figure out what's going on. And I kind of began to understand it.
And over.
And over. Yep. And so but they have this very regimented system that says our way of encouraging the development of resources is to allow you, operator, to not only form your unit, but you can force other people into it. I can like, unlike in Texas, we have the mineral interest pool. We have
you got contractual hurdles and
right.
things.
And there's some mechanism to do it in Texas, but not much. In New Mexico, I mean, every horizontal well that's drilled today
common practice. Yeah.
is subject to a compulsory pooling order. And again, the system works really well. And the way that works is I have a piece of land. I've by statute, I'm required to seek voluntary agreement. I've tried to do that. I've documented it. So now I'm going to go to a hearing and I'm going to apply for an order. And I tell the state, these are the wells I want to drill. This is who owns what. This is how are you going to divvy up production. These are all the reasonable efforts we've made to pool them. We couldn't come to an agreement. The state owns the minerals because typically speaking, who you're trying to pool is other working interest owners. Sometimes it's unleased mineral owners, but the majority of the time, it's other
working interest partners.
Right. Yeah. And so the state doesn't own a working interest. They own the minerals, right? So they're going to get 20% of the production. They want the well drilled. So they're not going to allow, like in Texas, before allocation wells, especially, you could have one or two holdouts really driving the ship. In New Mexico, no,
it's an economic decision in Texas.
Right.
Like, can I suffer this?
Right.
Yeah.
In New Mexico, the state says you're not going to stop people from drilling wells on our minerals.
Yeah.
And so, so you go to hearing, and the majority of those cases end up what's called proceeding by affidavit. So everyone will more or less come to an agreement and say, we're not going to contest your application for an order. And we'll talk about what happens when it does get contested. But when it does proceed and an order's granted, essentially what that's doing is that's the state writing a JOA for the parties, right? So like if you die in Texas or any state, if you die without a will, the state will write you one. That's the intestacy laws. Mm-hmm. If you get pulled without a JOA, the state's going to write you one in New Mexico. And that's going to be the pulling order. And it's the same order every time. It sets out who's the operator, how long do they have to drill the wells. It's just like a JOA. You would recognize it.
Straightforward.
But most importantly, like a JOA, it has a risk penalty in there. And that's where things get tricky in New Mexico. So I'm mom and pop operator. I'm operating I have 5% of an old vertical well, and now all of a sudden I'm getting force pooled, and you're going to have an 18 well pad. You're going to cash call me for all this. Oh my God. If I go non-consent under the order, at best, it's a 200% risk penalty.
Yeah.
At worst, it's
not getting paid
400%.
for God knows. Yeah.
Maybe ever, right?
Yeah.
And so that's done a couple things. It's created this liquid market for non-operated working interest in New Mexico because these mom and pops,
big business. I mean, it's a lot of the work that we do is just figuring that out.
Yeah, who owns it? So you can go buy it because these guys are underwater. They not only is it an economic opportunity of a lifetime because all of a sudden they're under the best rock in America.
Yeah,
but it creates an opportunity for. It's so hard to get in and operate wells, but to have just the capital required to do it, but just a few guys with some dollars could do the non-operated working interest. So it creates a real opportunity.
There's a whole segment of business that's spun off of that's been profitable. And it's been great. I mean, I guess maybe to step back just to kind of lay the groundwork a little bit for how you get into the situation. New Mexico has been, these federal leases have been, and state leases have been producing in large part in Lee and Eddy County for decades, right? Tons of shallow old production, federal and state leases that are held by production to all depths, that are at 50, 60, 70 years old in a lot of cases. And so working interest for people who don't work New Mexico, they have no understanding of like literally how complex the horizontal working interest breakdowns can be, because different vintages of productions throughout the time of these leases Leases are pretty easy to maintain. A lot of active production there. And so you could have infinite amounts of variation of ownership at different horizons based on the tracks within these units.
Oh,
So
for sure.
all these small mom and pops, people have had interest that they've, their great grandfather or grandfather, had, and it gets passed down just like in a will. These are assets that they own, they've got a working interest. Then all of a sudden, you to your point, you got a 18 well pad coming in, 6 mile lateral, 20 mile, 10 mile lateral. They can't afford it. That's when this kind of non-op business really started to flourish, to consolidate that. People who are well capitalized could participate in these wells and not suffer that penalty. So it's interesting. I guess the state said, "Hey, so be it. We want our minerals developed. Tough cookie, come in your business and clean it up." And that's largely what's happened, right?
Pretty much. Yeah. The
Yeah.
state wants a couple things. They want their minerals developed first and foremost, but they want to know, if things go wrong, who am I coming after? And the order sets all that out. It says, you're the operator, you're responsible for this.
Who's on the hook?
Mom and pops, non-ops, we don't care. And I don't mean that in a we don't care, but I mean that's not the concern of the state. And
You're not going to address my concerns.
No, exactly.
Yeah.
Exactly. But they so the state, so and like I said, the order's the same every time. And so not only do you have this whole industry pop up of the non-op working interest owners, but you also have some people who look at this, and let's say you're there's several of these old Yates entities that are left out there, and they own, acreage in some of the best basins, and they don't want to go to every single hearing and show up and sign a JOA. They're like, we know what the order is going to be. I know I have the money to participate. I'm just going to participate under the order. That's really common. It's just a problem. Participating under the order is a problem when you can't actually participate. That's where people get in trouble when they get subject to this penalty.
That's where it has to clean up. So just to kind of, for comparison's sake, New Mexico, you've got 3 units established, 3 compulsory units in place, been there forever. Operator wants to come in and drill, a 3-mile lateral, combining and producing under all those 3 sections, those 3 units. Is the process the same? They're going in to go through that hearing, do their application, get their force pooling authorized, and then they're off to the races? I mean, is that essentially how it
Pretty
works?
much, yeah.
Yeah. So it's just
a
regulatory process to be able to accomplish, to keep up with the technology, essentially.
Exactly. So they retooled that legislation in 2018, I believe it was, because they were running into the square peg round hole problem of, man, we have this compulsory pooling framework set up for vertical wells, and it's not working with the horizontal wells. Let's amend it and add to it to accommodate horizontal wells. And yeah, that's what they've done. It's a very repeatable process, but where things get interesting is, I send you a letter to say, hey, Dudley Oil, I'm applying for a well. I want you to sign a JOA. And you say, no, I want to drill this acreage.
Yeah.
And then, so you send me a proposal back, and then I send my application, you file an application, and that's what's called a contested hearing. And that happens, I don't know, a good number of cases start out at least contested, because it could be just people jockeying for position or better terms, or, but it could be, in fact, 2 operators really do want to drill it, and they have different ideas about how to do it.
Different
And
technology, different, I'm better than you are,
Right. Oh yeah. It can get as rational and irrational as you can imagine.
Yeah.
On both sides
Yeah.
of the
Oh, you
spectrum,
screwed
but,
me on this other deal, so I'm going to delay your drilling schedule by contesting this, and maybe that's leverage for this other deal.
I can neither confirm nor deny that those things happen. Put it that way.
So you have a contested hearing. What happens? Like, how does the state navigate that?
So it's a trial in front of a hearing examiner and a technical examiner. And you essentially, each side puts on their case for, this is what we want to do, and this is why my plan's better. And essentially the burden of proof for each party is just on, my plan's good, right? But I have the opportunity to essentially impeach your case and say all the reasons why your case is bad, right? So you have to put on testimony. The landman comes and talks about, this is the way we've set up the units. This is who owns what. And you start getting the arguments about, well, we own more in the unit than they do, and both sides will fight over that. But where the real fight usually is on the technical side, where you have an expert for each party, each contestant saying, we want to drill our wells. This is why my drilling program is better.
Okay.
And then
so
the other side
land,
gets
there's the land argument, and then there's the technical argument that's engineers,
Right.
geologists, whatever it might be.
Right. The land argument is kind of like, is it fair for me to be the operator? You know,
Yeah.
I've tried really hard to get everybody to agree, and I own a lot of it, and so it's fair for me to be the operator.
Yeah.
The subsurface technical side of it is, we think we can pull more hydrocarbons out of the ground, or we're going to disturb the surface less with our plan, or things like that. And both sides get to cross-examine each other's witnesses, and it can get kind of spicy at times. So it's fun.
The fun stuff. And then the commission makes a ruling, and that's it. You go after it.
That's it.
All right.
I guess there's certain limited appeal options, but practically speaking, once the division, once the division rules, that's what happens.
That's it. All right. Pretty straightforward. New Mexico has its own complexities at different stages of the game, but to your point, when we started this all out, both effective, both work given the circumstances, right? Yeah, man, it's been a great breakdown. We talked for an hour about pooling.
Yeah.
Hopefully,
Who'd have thought?
Yeah, who'd have thought it? But to your point, man, there's a lot of nuance on these other things. I'd love to visit with you and have another podcast talking about some of these other topics. But that's great, man. Obviously, you've got a vast experience now. You're well versed on it. Ton of experiences. Thank you for kind of unpacking that and just the basic terms. I think some folks will get some good use out of it. Like we talked about earlier, different people in our industry hear these terms, know these terms, but don't get involved in like this stage of the game. So our goal is to accomplish exactly what we did today, lay it out for someone who doesn't live with it and work in it constantly, but now they have a better understanding so they can maybe be better at their job.
You bet.
So,
And we have, so when I was in-house, kind of close with this, and one of the reasons I do so many CLEs, when I was in-house, I realized really quickly, oh shoot, I'm dependent on other people for my knowledge, and I need this knowledge, right? So I need to trust who's giving it to me, and I need it, right? So we have gone really hard in the direction of publishing a lot of resources on our website. And so if anybody out there wants to learn more about it, I would say visit our website, theenergylawgroup.com. We have the thing called resources tab, and it doesn't cost anything. It's just all these PowerPoints and presentations. And it's got my contact information there too. So if anybody ever has a question, wants to talk off the record, give me a call.
you bet, man. Yeah. So what's your website again?
energylawgroup.com.
All right.
Yeah.
Perfect.
We'll link to it in the show notes.
Yeah,
You
we'll
got
put it
there
in
for
show
listeners,
notes.
and your LinkedIn
They can
as well.
find you
We'll
on
put that
LinkedIn
there.
and all the things.
Yep, LinkedIn. I'm pretty
Yeah.
active on LinkedIn as well. Yep.
Awesome.
Yeah.
Well, Ben, thanks, man. I appreciate you diving into this and answer some of the basics for us.
Yeah, man. Thanks for having me.
Awesome.
Appreciate
Yeah,
it. See you,
enjoyed
Nate.
it. Yeah, you bet. We'll see you.
Enjoyed today's topic? Follow us on Spotify, Apple Podcasts, and YouTube. Learn more at dudley-land.com. See you next episode.